in particular on the developments which have taken place leading to the new law which we have now, the Competition and Fair Trading Act of 2024. I should also at the onset say, I don't know whether one or two colleagues of mine have joined. I was expecting Angela and others to join. They may have joined. I can't see them on the screen, but let's proceed. But first, I think, as I said, to express our sincere gratitude that you have remembered us so that we can share our story with you. And so that for those who didn't know about Malawi, I don't know if there's any who didn't know, but for those who may not have known about Malawi, I think it also gives us an opportunity that we put our message across. Yeah, so by the way of background, anyway, let me also recognize George Napambo, indeed our former commissioner on our board. It's excellent to have him so that wherever I may have left out something, he's well respected and experienced to cover me up on the subject matter. So by the way of background, the competition enforcement in Malawi started in the early 90s. Should we say late 90s, with the promulgation of the Competition and Fair Trading Act of 1998. And that act has driven our enforcement work since 1998 up to 1st of July 2024, quite a long period of time. That law has been in operation. And obviously, you would agree with me that it has been 25 years of a law that never went through any amendments, but yet it's a law which you use to regulate the market, but the market has been changing, has been evolving, but we never had an opportunity to amend the law to reflect the changes that were taking place on the market. So obviously, as the time passed, the gaps in the law became obvious, that we couldn't effectively now enforce competition and consumer protection with the law as it was, because a lot was happening. The markets had evolved. We didn't have digital markets 25 years ago. Now the markets had come. We never thought in our lives when that law in 1998 was promulgated that actually we could have abuse of power from a buyer. We had that traditional thinking that the one who abuses the power is actually the seller. So the abuse of dominance was basically just looking at the seller. But as we moved on, those challenges became so clear that we needed at least to do something to the law. So we have had quite a lengthy process to be where we are. But to cut the story short, is to say that we finally had a blessing that on 5th of April, Parliament gave a nod and passed the new law, the Competition and Fair Trading Act of 2024, which effectively repeals the law of 1998. And we have had to go through the processes of the president assenting to the law, which happened on around the 19th of May. And then there was a requirement that the commencement date for the enforcement of the law has to be by the notice published by the minister. And that notice was published on the 20th of June, giving the 1st of July 2024 as the effective date for the implementation of the new law. So as of the 1st of July, we are now effectively implementing the new law. So in short, what has the new law addressed, which possibly was lacking in the previous one? Maybe I need to expound. I may not go into everything, but I'll just go to the salient issues which are there. The Competition and Fair Trading Act of 1998, we always refer to them CFTA as abbreviation 1998. On the issues of major notification, let me start with major notification. That law of 1998 provided for voluntary notification of measures, and then there was no provision for any thresholds. So anything which resembled a measure had to be notified, but if they so wished, otherwise it was voluntary. But there was a caveat that if somebody happens to consummate a measure which has which leads to competitive effects on the market, that person commits an offense. So would go back and then to say, no, after assessment, your measure raises competition concerns, but you had the audacity of effecting it, so you commit an offense. That offense actually was criminal in nature, as per section 51 of our law, where violations of the law were criminal in nature. So it became quite problematic. But now, in short, what we have done is actually to move with the tide of the international best practice. Now notification has become mandatory. We have now a suspensory major notification regime, and the law now provides that we need to pronounce the thresholds for notification of those particular transactions. So that is one of the major changes which the new law now encompasses. The second one is we had a problem with the issues of a consumer. The definition of the term consumer gave us a lot of problems because the 1998 law had quite a narrow approach to the definition of consumer, basically looking only at a person who was the end user of the goods or services, not necessarily the one who bought. You can buy, but the user will be a different person. So we have actually this time around in this law tried to expound to capture all the scenarios of the intermediary buyers, where now the consumer provides for intermediary buyers, but also, the beneficiary buyers, consumers, because I can buy the good, I can buy anything on the market, but maybe I may not end up being the one who is going to consume that particular product. The consumer, the end consumer, may not be the one who has bought it. But the way the narrow definition we had presented that problem, so we have tried to coach it in a way that we capture a consumer in different scenarios, and also including now the consumer of digital products. There was nothing mentioning of digital products in the law of 1998. Not that it was forgotten, but it was not an issue. It may not even have been there to be captured by the law. So that one is another way of trying to broaden up the definition of a consumer. We have had cases where there were companies who were buying a product. Let's say you buy sugar from a manufacturer, but you want to use that sugar for the purpose of manufacturing sweets, for instance. then under the consumer protection law, how it was framed, you may not position yourself as a consumer because so a lot of those scenarios came, which made us a bit problematic to handle some of the cases, which may have looked straightforward, but the lawyers would actually have a fist on you if you try to twist something which the law does not provide. The third aspect which we looked at, we are basically an agricultural economy as Malawi, and over the years, we have noted the challenges which particularly our farmers go through, where the small-scale producers of produce like maize, soya, and what are subjected to contracts by the big buyers, where they're subjected to very unusual kind of contracts, utilizing their negotiation or whatever power they have to exploit the small-scale farmers. And even the contracts have been dubious ones, which are written in a language which nobody, the other party doesn't even understand. Again, taking advantage of the same bargaining power which we have experienced in person as a country over the years. But when you went to the law now, how do we protect these farmers who find that we are lacking? Was the issue of abuse of the power, as I said in my opening statement, was limited to the seller. So you'd expect the seller of the product, they want to exploit the buyer. But then the story has been changing. The trend has been something else, where actually it's the buyer exploiting the seller, taking advantage of the bargaining power which they have. And that is what has made us introduce the concept of the abuse of buyer power, which was not there in the previous law. But now we have included it to ensure that the law prohibits enterprises from abusing their buyer power when they are buying farm produce from vulnerable farmers. But that has just been our focus, but it's not like it's restricted just to the vulnerable farmers, but it may be even expounded to other scenarios. But the issue of the experience of the farmers was the trigger point for us to think of introducing this particular concept. And my colleagues from consumer may have joined, they will expound it even better when we come to the clarification of some of the aspects which we have added. Then the fourth aspect I wanted to add was the issue of penalties. We have had a challenge with the issue of penalties because our law basically provided for criminal sanctions where you would pay a particular fine, but also be subjected to some years imprisonment on how the previous section 51 was written. You pay the sum of this and imprisonment to 5 years for the violations. So over the years, since we started enforcement in the around 2008 or so, we have had to choose to play some shortcuts. So we're just imposing that first part of a fine. And the fine was just 500,000 kwacha. I don't know in dollars how much it could be. We'll calculate and tell you later, but it's a very minimal figure. But in 1998, that was a huge figure, a very huge figure 25 years ago. But it remained that particular figure, and we are levying that until I think last year, where we had tried to use the concept of financial gain, because there is also a concept of financial gain, a fine, an imprisonment, or a financial gain from the misconduct. So we find a big company based on financial gain. And they paid quite a substantial amount of money. But lawyers being lawyers, they went back to our law and found out, we say, no, I think there's a loophole there we can use to get back our money. And the loophole is what I'm saying, that the coaching of the previous law was that I think the sanctions were criminal in nature. So they went to court, and the court sided with us as a commission to say your findings were very perfect. This company violated consumer rights in Malawi, but the court finds that you didn't have the power to levy this fine, because as per the wording of your law, I think these violations are criminal in nature, and they ought to be referred to the Office of the Director of Public Prosecutions for criminal sanctions. So after keeping that huge sum of money for 2 years, we had to refund it with tears. Yeah, so we refunded, and so to address that, the current law now introduces not something which is strange, but which is also already being practiced as per the international best practice, to the extent that now the fines and the penalties are now levied as a percentage of the annual turnover, which can be up to 10% of turnover for an enterprise, and up to 5% of turnover if it is an individual. So that is one of the major reforms which have happened under the current law. The last one I may need to highlight, I know there are many, is the issues of concerning the adjudicating board itself, the commissioners, of which Councillor Campbell once used to be part of them. The current law has put in some mechanisms now to ensure that, one, the qualifications of those commissioners have to be up to standard to handle the task that awaits them. And secondly, there must be a security of tenure. So unlike the previous law, which did not specify qualifications for the commissioners, this one actually has specified qualifications and experience of those people who have to be on the board to determine the cases, but also after being appointed by the minister, now the appointing authority will be the minister. Previously, it used to be the president, but now it will be the minister. But those appointees will be subjected to parliamentary approval. So the names appointed by the minister will be submitted to Parliament for scrutiny, and if they pass that, then that appointment will be taken to have been completed. And the removal process will be also the same. The minister, if he desires to remove a commissioner or all of them, has to convince Parliament. Parliament has to give a nod and to be convinced of the reasons why the commissioners are being removed. So we have put that deliberately, knowing the kind of work which we do. Sometimes we step on the toes of the people who are decision makers. So maybe the easiest way is just to remove you so that you don't continue causing trouble. So we have put those secure safeguards so that there is a continuity in the adjudication process. of the Commission. The other aspect which I said we have, for the first time, I alluded to the issue of digital markets, which we have included for the first time. For the first time, we have put it in the law. Let me say at the onset that it's uncharted territory, which we need to also understand ourselves, because it's not a territory which we have handled in depth before, but now it's provided in the law, and that's where possibly, with the help of the other advanced authorities who have handled these particular matters, we could get the best practices on how they have handled these particular matters. But suffice to say, we have, as we move on, there are quite a number, a few dilemmas which each and every competition authority has, which also we are looking at to see that there's need for an enhancement of capacity and appreciation of this particular subject matter to ensure that the enforcement and the resultant determinations the commissioners make should be well grounded and well reasoned, as not to actually misrepresent the issues pertaining to the digital economy. So, just as the Africa Continental Free Trade Protocol on competition is very rich on digital markets, COMESA, they are also reviewing their regulations now, and the issues of digital are also coming in quite strongly. So we don't have to be left behind, but we also don't have the privilege of not tackling it, because this is a reality. These are the markets which are with us. The traditional markets possibly very soon may be overtaken, if they have not already been overtaken by what is happening on the digital market. So we anticipate quite a lot of work to develop actually the guidelines on how we tackle some of the complex issues relating to digital markets, such as the online searches, the social medias, the marketplace, e-commerce, and the mobile operating systems, and all those matters which pertain to the definition of these digital markets. We ought to understand them better, because we appreciate some of us who have been exposed a bit, not in an advanced way, on such matters, that possibly the assessment and the tools we need may not necessarily be what we use for assessment of these conventional competition cases. Possibly we need more. The issues of overpricing or underpricing, consumer welfare, all those things we use when we are determining abuse in these other matters may not necessarily be just transposed as they are when we'll be dealing with the digital markets. And then we also have to boggle to say, how are we going to be defining the relevant markets in these particular digital markets? It's not as easy as the SNP tests or the market shares we use, the concentration ratios, the HHIs. In digital markets, it has to be something else, something which, yes, it may encompass this, but there must be something because of the nature and the evolving nature of these particular markets. So we are already thinking around that so that we can pronounce ourselves properly under the guidelines. And when these digital companies will be merging, there is a merger involving them. What are we going to do? What will be the public interest issues, the efficiency rationales? Where are we going to? So quite complex matters which we need to deal with on digital markets. But suffice to say, it's now with us. The most important message I wanted to convey is that we have joined now the international best practice in recognizing that we now have digital markets and our laws have to recognize that, and we have to find out the best way in which we can enforce competition in this particular market. And with the help of the international best practice and also enhancing our own capacity for staff to understand this peculiar kind of a market, we should be there in no time. The beauty now is that after the law was made effective on the 1st of July, we are now in the process of developing regulations, because the regulations have not been completed yet. And the regulations will be followed by some guidelines on some of the key aspects so that we should be able to link up with the stakeholders. They should be able to know at least how we are going to approach our assessments in the different aspects of this particular law, be it measures, the BRPs, abuse, and even these digital markets. How are we going to approach? We need to pronounce ourselves by way of clear-cut and easy to understand guidelines so that our system on the side of the stakeholders is understood and is predictable. It doesn't swerve by situations, but is something which they can rely on as being guided by a clear-cut process in which we are going to use to approach this particular cases as they come. So maybe I may have even surpassed my time for giving an intro, but I thought being our first time to pronounce ourselves, let me make a bit of let me beat up a drum over the limit so that you help us to build up a system, an enforcement system that will stand the test of time. So I don't know whether my colleagues, I'm not sure if Angela and others have joined.
Yes, they have.
If they have joined, maybe Angela, you can have some input on the consumer aspects. I don't know if we have anybody from competition to also add something or even contradict what I've said. It doesn't matter.
That's fine.
Thank you. Thank you.
Thank you so much, Lloyd. Thank you so much. Angela, do you have something you'd like to add before Leonard and I ask questions?
Yes, thank you. And thank you, Mr. Nkhoma, for the elaborate presentation of the changes in our law. I just wanted to add just two aspects, and the first is on the consumer aspects. Mr. Nkhoma talked about the changes in terms of the definition of the consumer. The others are just an expansion on the unfair trading practices or consumer violations, and specifically the issue of unfair contract terms. So the Act of 1998 did not have any aspects to do with unfair contract terms. To deal with these issues, we were using were using charges of unconscionable conduct to deal with them. But now we have the Act of 2024 now has aspects of unfair contract terms. So we believe that these will be able to help us, because almost half of the cases that we deal with in terms of consumer cases are to do with unfair contract terms. So having an express provision as it is really helps. The second aspect I wanted to add is on the issue of regional cooperation. The Act of 2024 brings in the issue of how the CFTC will be cooperating and collaboration in light of the regional blocks, like the COMESA Competition Commission, whether it's the competition protocol under SADC, and as well as the African Continental Free Trade Area protocol on competition. So the regional cooperation aspects helps, because now it sort of formalizes the cooperation and the collaboration that is there, considering that now we are living in a global market. We have issues of common interest in the in the regions. We have an opportunity to have to implement the decisions that are made at the regional level that have an effect on us as Malawi. So it is very important that it is that. Otherwise, in the past, we were just relying on MOUs, which may not be legally binding. So introduction of these provisions of regional cooperation is very important. Thank you. That's what I wanted to add.
Yeah, thank you so much, because I was really waiting to hear from you regarding the issue of regional cooperation. So I have some questions for Angela and Mr. Nkhoma as well, regarding some issues that I would really want to understand. And the first question is relating to the legislative process that led to the amendment of the Act. And some of the issues I would like to know is, you indicated that you are learning from international best practices. So who are these who really informed the amendments? Where were you learning the lessons from? Which actors were involved? How are they able to support you? And then the second one is in relation to cooperation, regional cooperation, Part X on cross-border cooperation. And the last time I was at the commission, when I was in Malawi, doing some interviews on your interaction with the COMESA Competition Commission, I would like to know how far Malawi has gone with the domestication of the COMESA Treaty, because under your section 60 to, I think should be section 64, where it's clearly indicating that you will cooperate with the regional competition authorities or regional consumer protection authorities, whereby Malawi has domesticated those treaties. What is the implication of the issue of domestication? Have you domesticated the COMESA Treaty? Have you not? Will it affect your cooperation or not? And then on the issue of sanctions, and I've seen that you have a leniency program. You expect to have a leniency program. And I know in Africa, in most of African countries, the leniency program has not been successful. So how are you going to approach the issue of the leniency program in order to make it work? And thank you so much for bringing up the issue of digital product and services. And I can see clearly under Section 24 of your Act, you've been able to ensure that the anti-competitive conduct or the restrictive trade practices that platforms are likely to engage in, or any undertaking is likely to engage in, also covers digital markets. But I would like to know which abusive practices are you anticipating in Malawi regarding digital market regulation? And people have been asking even before this event is, when are we expecting the merger thresholds? That is really what people in the corporate world and legal practitioners would like to find out. And then on the issue pertaining the role of judicial officials, I can see now we have a section regarding the role of the court in Malawi. And I was just wondering whether it was intentional not to have a competition tribunal in Malawi, because I know from other practices, most countries have a competition tribunal. And the final one, I would like to know if there was things you included in the first draft in your legislative processes, if they were excluded and then they're not part of the law, if there was any contestations from the stakeholders, and that is why some of the issues were excluded. I hope the questions are not too much.
Yeah, thank you very much. I hope I'm still audible. Let me start with the legislative process. What informed the amendments and who was involved. Actually, the process of amending the act started actually with the consultant who worked on the initial drafts, and that consultant was from Europe. But after that, those drafts have been subjected to quite extensive stakeholder consultations, both at national and regional. So we had quite the business community were involved in putting up their own thoughts, the legal fraternity, the consumer associations, even the civil society also were involved in this particular process. And of particular mention, COMESA. COMESA Competition Commission was heavily involved in this particular process. Why? Because when we are doing this process, COMESA were also, and actually now the process is also going to an end, they were also reviewing their regulations of 2004. So in the spirit of ensuring that there are no potential conflicts between the national and the regional competition laws, they were very much involved to give their inputs into this particular process. And also we have had feedback from a number of even competition law practitioners in the region who also have commented on the initial drafts, leading to the process where now we had to say, I think we are good to go and take this particular drafts to the Minister of Justice and to Parliament. So it has been a quite extensive consultative process, and we are happy with that process, and possibly wouldn't have been where we are had it not been for that process and the acceptability of the actual law would have been a challenge if the key stakeholders were not involved in its process. So to answer that one, many actors involved, both national and regional. And we also had the protocol at the continental level on competition in mind, because we are also a subset of that particular continental body. So the developments at the continental body were also of an interest to us, so that we also align our law to those aspirations which are obtaining at the continental level. So there was quite a lot of referencing. And actually, one of the laws which actually inspired us to go full throttle on the digital markets also is actually the continental one, because it comes out quite an equivocal on the issues of the gatekeepers and all those aspects pertaining to the digital markets. Now on regional cooperation, I'm glad my former commissioner is here. Maybe I'll leave it to him to comment further on this. But yeah, domestication of the COMESA treaty has been a lengthy process, which started, I think, for Malawi, we made an initiative to go that route, but it's a process which has not been satisfied up to now, and Commissioner Napambo will explain better. But if you look at our provisions on cooperation, was actually in a way to say, while this process is moving on, what is it that can be done in the interim to show that we do not frustrate the regional enforcement processes? Just as our colleagues in Uganda and other countries did. So it was in a way trying to indirectly, not domesticate. I don't want to be like we are domesticating indirectly, but try to find a way to say, okay, we have accepted this regional enforcement mechanism. And as Malawi, we are hosting, we are the hosts of COMESA. And it will be an embarrassment that will be one of the countries which is not actually recognizing the regional decisions and enforcing them at the national level. So that was what inspired those provisions on regional cooperation. And if you see, we have even expanded to multilateral, because we are already looking at the Africa continental supranational competition enforcing body coming into play very soon. We don't want to go back to say, no, we had just talked about regional, so these people, we need to amend the law. No, it's covered looking at them. Even if WTO today thinks of having one, then we are more or less covered by those particular provisions. But I will leave it to Commissioner Napambo, lest I misrepresent the legal matters. I'm an economist. I don't want to dwell much on the legal matters which I may end up misrepresenting, but just to say those provisions were more or less aimed at addressing those particular challenges emanating from the absence of the domestication process. On sanctions, leniency program, it hasn't been successful. Yes, our law provides indeed that we should promulgate a leniency program and actually settlement procedures. There are two new things which I should have mentioned actually at the onset, which were not there in the old law, leniency as well as the settlement procedures. And you are right. I think looking at the history in the region, except South Africa to a larger extent, possibly leniency program hasn't worked to the satisfaction of the authorities which developed them. Zambia also tried a bit, but not to the level which it ought to be. So I think there are things to be learned from our side as we develop that leniency policy to say possibly the traditional way of doing it may not work. Maybe we need to have an entrenched, homemade kind of system which speaks to our situation, but without losing the gist of what leniency program ought to address. I'm just thinking overboard, but honestly, we have not had time yet to discuss on how we are going to frame it. Except possibly at COMESA, we had made, when I was a staff member there, we had made an attempt at one point to come up with one, but we realized that it can't work if the national authorities that don't have the same. It will be just an academic work, so we dropped it. Yeah, it's worth a try, and we'll see how we can configure it. But to give you an honest answer to say this is the best way we intend to do it, will be maybe just selling fallacies, because indeed the challenges which leniency program has faced in the region is a wake-up call and a lesson to us who are developing those programs later, like Malawi, maybe to thoroughly study and understand what have been the challenges in the other jurisdictions, and then how best possibly can we frame our leniency program to ensure that it works. What's the culture of our businesses? We have those businesses which can even voluntarily come to you to say, I want to come and betray my colleagues. We have those cultures, or they have those mentality that if we sink, let's sink together. So the cultural aspect of the businesses also want to be properly contextualized. And then the rewarding system, once that person comes, it has to be maybe properly also contextualized to ensure that we come up with something which is not just academic, but something which is going to work. But as we move, definitely, this is not our last interface. Next time when we discuss this, I think I'll be able to pronounce to say, as Malawi, we have sat down, looked at the challenges, confronting our colleagues, and possibly this is the way we have thought of moving, because it will be also a text which will be subjected to quite a lot of interrogation. And possibly you'll be one of the people to input into that to ensure that we come up with something which is workable. So for the time being, nothing concrete I can prophesy, but just the hope that we would be capable to come up with something which is workable.
If you could wrap up in the next 5 minutes on the other questions.
Yes, I will wrap up. Major thresholds. Yes, the question was, when do we intend to come up with the major thresholds?
Yes.
Yes, it's very soon. Actually, yesterday, actually, we are rocked up in a meeting looking at the final draft of the regulations. And in there, we are going to pronounce the thresholds. The beauty with this is that we are already locked up in another regional negotiation to input into the thresholds for the Africa Continental Free Trade Area. So, yes, and we have the thresholds, the regional one, which we can use COMESA as a reference point, because they have those major thresholds at COMESA, at Continental. So for us, as national, the guide is already there to tell us, and also looking at our GDP, the size of our businesses, and all those aspects which we are discussing to ensure that we come up with thresholds that are workable. But we are envisaging that in the next 2-3 months, we should have regulations actually given a nod by the minister. On the competition tribunal, in our case, possibly it's an issue of now these financial capacities because to keep on creating layers of institutions to look into those matters, possibly it will be financially very expensive for us. So Secretariat, then we have the Board of Commissioners to make the determinations. If somebody doesn't agree with the outcome, they go to the court. And the law now has clearly stipulated that they'll go to the commercial court, which now lessens the burden of what we had last time, where the court was not defined to say which court they will go to. So I think for the time being, I think it works. On issues excluded from the first draft, maybe Angela may come in. I can't remember. Yes, the law from what the consultant left and what came out, there have been quite a number of changes, but some of them have just been semantics. But I know that looking at the behavior, especially on consumer, one of the things which the consultant agitated was for us to introduce the spot fines, but that was dropped at consultation processes. Obviously, the reason is very clear, is that because the system demands that the decision-making process is at the level of commissioners, not secretariat. So if you impose a spot fine, it means you have made a decision, not the market, usurping the power of the commissioners, and you want to be in the spirit of the law. And again, how you determine that spot fine, it will be a lot of arbitrarity, a lot of corruption on the market. So we agreed that one was thrown out, but maybe Angela, because my time is up, we can come in with maybe, because I found when I joined, I found the process of reviewing the law already, possibly midway or 2/3 done. So maybe Angela, being the seasoned person in the institution, may have something tangible which has been dropped. No, I thank you so much. Let me end up.
Oh, thank you so much, Lloyd. So I know now we can now listen to George to give us the aspects from a practitioner's perspective and also his involvement and fill the gaps that you've not been able to address. Welcome, George.
Thank you.
Don't worry, we have around 30 minutes time, so take your time.
Okay.
Yeah.
All right. Okay. No, thank you very much. Basically, I'll just look at some of the issues that the Act has left out, so that I feel are gaps. So I did a few slides. So I'll just share the screen shortly. Just hold on.
Let me make you a host.
Okay.
Okay.
I guess you can see. I'm not sure if you can see.
It hasn't come yet.
Oh.
Yeah.
Okay, yeah.
We are good now, yeah, sure.
Okay. All right, yeah. So I think some of the key issues have already been addressed by the CEO. When we did an analysis of the old CFTA Act, we felt that there were some of these issues that I think lack of administrative fines, I think that has been addressed quite well in the Act. And as the CEO also mentioned, the reason why this also came up and why it was necessary to address in the new Act was because there were several court decisions that actually held that any administrative fines that the CFTC had actually imposed were illegal. Why? Because the Act itself, the old Act, the framework was that any breach of the Competition and Fair Trading Act at the time was a criminal offense. So you can't then impose administrative fines when you have when the procedure is supposed to be a criminal one. So they found that any other fines that the Competition Commission had actually meted out were in violation of the actual act that was in place at the time. So so the court then nullified on these fines. And in a sense, what happened is it meant that the CFTC was hamstrung. It couldn't do much, especially after finding wrongdoing by various parties. The only option that they had was to now impose, institute criminal proceedings, which was also outside their hands because they had to then bring in what the government department called the Director of Public Prosecutions, which has the authority to do all prosecution. So that affected some of the efficiency of the CFTC. And for a while, you find that, I think they didn't do much work other than advocacy, or unless where there are negative clearances. That's when they also came in. On the issue of transactional thresholds, again, that issue, there's an enabling provision in the act, but as the CEO has mentioned, there aren't any regulations yet. And I think that is important to have those regulations in place. The reason why we're saying that is because now, obviously, if the system is a mandatory system where you have to notify all mergers, it means that sort of you're catching each and every transaction that is happening in the market. Some of those transactions might be small, very small in nature, and might not even have an impact on the market. Okay, so with the requirement that all mergers have to be notified, it means that there'll probably be a floodgate of notifications, so to speak. And again, it also just affects the efficiency of the CFTC. I mean, I think they have to focus on some of the main issues, looking at what's happening in the market, some of the violations there, and also looking at the size of the organization itself as well. I think last time we were there, I think there were issues to increase the number of employees with the CFTC. So the issues of capacity, whether they can deal with each and every transaction, I think it just highlights the need for thresholds. Now, the mere fact that there aren't any thresholds doesn't really mean that there isn't any hope. Because I think if you look at currently, I think the issue that we're dealing with under, I think, Section 35 of the Act, it states that transactions that are subject to merger control are those transactions that are carried out by enterprises. Now, if you look at the definition of enterprise, basically you're looking at companies, partnerships, and various other firms. It doesn't include, for instance, the impact of private persons and individuals. And I think some of the areas where we found that there are issues to do, there are competition issues, is in areas like, for instance, the commodities trading, agricultural sector, where most of the players there are not really enterprises as defined by the Act. They're just private individuals who can exercise significant market power. They can affect prices, and they can also do certain things that actually affects the market. So the definition of enterprise itself, we feel perhaps it should have also been extended to private persons who have significant market power and who have significant market influence. Another sector where we feel that private persons might have a significant power in the market or dominant power in the market is a construction sector. For instance, you find that there are some construction firms that are sole proprietors, meaning that they're owned by private persons, but they're able to do very big contracts in that area. And they might exercise also significant power in that area. So it means that if you look at the definition of enterprise as it stands in the Act now, in the new Act, it means that even these players who then are not actually violating the Act as it stands, because it only applies to enterprises. So I think that definition of enterprises needs to be looked at to at least capture these sort of players as well. And again, like I mentioned, now the issue of thresholds, though we might not have thresholds, but the Act also provides under Section 50, the new Act, on issues to do with negative clearance. Okay, so here, this is a procedure where if you feel that your transaction doesn't have any competitive issues, you can actually ask the commission to give you what you call negative clearance. So they'll then look at your transaction and say that, look, we feel that from the preliminary investigation that we've done, we feel that there's no need to actually go ahead and do a full investigation. Your transaction, the way it is, it won't have any effects on the market, and therefore we are approving it. I think there's a similar procedure under the UK law, where what they call the phase one review of a transaction. So the CMA in the UK can make certain decisions after reviewing it during that phase one. If they feel that more investigations need to be done, they move to a phase two review. So it's a similar procedure that is there under this act. And we feel that even though we don't have thresholds, but this can then be used to also limit the number of transactions that the CFTC goes on to investigate. Another issue, I think that has already been brought up, is this issue of though all transactions not all transactions are viewable under the act. We find that even the Commercial Competition Commission, it has jurisdiction in Malawi. Okay, and under that, their regulations, they already have thresholds. And if you look at the number of transactions that the CCC has actually assesses compared to what the CFTC assesses, you will find that most of the mergers in Malawi are actually being reviewed by the Commercial Competition Commission. I think the statistics that show that between 2022 and March 2024, the CFTC assessed about eight transactions only, while the Commercial Competition Commission assessed about 23 transactions. That's because obviously most of those transactions have a regional impact or have a cross-border impact, and then it means that the Commercial Competition Commission will step in. So we believe that brings in that check. So as the CCC also has thresholds, and these are still, that means that in a way they are being applied in Malawi. UNCTAD did a review of Malawi's competition framework, and I think they also found that at least on average, 67% of all mergers in Malawi are assessed by the Commercial Competition Commission. So though we might not have these thresholds, but we believe that looking at the act and some of the provisions there are some mitigating factors. But of course, we believe that the introduction of thresholds, if you have thresholds, it just creates that certainty, and then it also reduces the amount of notifications that are being made, allowing the Competition Commission to actually focus on key transactions as well. Other than that, another issue that we felt needed to be considered was actually the appointment of commissioners themselves for the CFTC. Now, what you'll find is that under the Act, and again, also under the old Act, what the term of commissioners was about 3 years, and it was renewable. Now, usually you find that there is a gap between the time the term ends and the time new commissioners are actually appointed. And what that does is, again, it also hamstrings the effectiveness of the CFTC, because it means that even if various parties have notified the transactions, investigations have been done, the CFTC, the commission is not there, the Board of Commissioners is not there to actually make a specific decision whether or not to approve that transaction. And of course, it delays, it creates delays and bottlenecks in the whole process. So we felt that either when the term of the commissioners expires, they should continue working until a new board is sworn in, or what we felt was there should be another way of ensuring that either identifying certain members. I think the board itself has ex officio members who are there all the time, whose terms are not limited. Mostly these are government appointees, and maybe those members, as their terms never expire, then they can go ahead and play the role of the Competition Commission until a full board is appointed. So we believe that provision should have been included in the current Act, because again, it affects also the functioning of the CFTC. Especially now, if you look at the quorum, I think the quorum is that 2/3 of the commissioners have to be present in order to have a meeting. And again, that means that if any of the commissioners are not there, then again, no decisions can be made, and you'll have to wait for the proper appointment of commissioners. We felt that the comparison with the Deposit Insurance Corporation Act, which is this is an organization in Malawi that is there to protect the deposits of people, of customers in the banks and other financial players. In that particular act, what they've done is they've actually mentioned that there's an executive committee which will take over whenever the board has not been appointed, or when the terms of the board members has expired. This is basically just a committee of ex-officio members, and they'll be able to perform the functions of this particular organization. Okay, so that creates, it then seals that gap that is there whenever the terms of the commissioners have actually expired. So I think, in my view, these are some of the key things that we picked up. Another issue of, if you look at the first slide that I posted, you find that this issue as well of remedies, whether the CFTC can issue, for instance, can order divestitures, for instance, when they find that there's an organization that has a dominance in the market, and meaning you split a particular, you ask disinvestment from an enterprise, or for instance, you force an enterprise to sell its assets. There's that provision now, but it only applies when they are assessing a particular merger. What happens after the merger, for instance, has been approved, and again, or for instance, maybe the merger was approved, but then this company still has, this enterprise still has a dominance in the market. Can they still order this particular remedy? Do they have access? Does the CFTC have the option to order this particular remedy for splitting various organizations that are too big to fail, for instance? So those are some of the issues that we felt needed to be looked at. Finally, I think under the Companies Act, you have also various takeover. They have also what they call the takeover rules under the Companies Act. We felt that there's a need now to link the current act as well as the rules, the takeover rules, because they also deal with practically the same issues. And again, you'll find that when you're trying to do a transaction, you then have to get authorization from the CFTC under the Act, the CFTC, the CFTA, and then you also have to go through this analysis of under the takeover rules. So we feel that there's some sort of duplication, and there's need to harmonize the two pieces of legislation. Other than that, I think that's it. Just addressing the issue of domestication of the COMESA competition regulations. Yes, this issue was actually one of the issues that was also identified. But now, if you look at that section, section 61 in the new act, though we haven't officially domesticated it, the regulations, commercial competition regulations, what that section says, it says that any decision of a multilateral competition authority or a regional competition authority can also be filed with the courts in Malawi, and then such decisions will become enforceable in Malawi. So what that essentially does is, it then means that any decision of multilateral competition authorities or regional competition authorities will become enforceable in Malawi as long as they have an impact in Malawi. And in a way, yeah, so it means that it gives efficiency and improves the enforceability of multilateral or regional competition authorities. But nevertheless, we still feel that, in my view, I think some might still want to challenge this approach, because obviously the approach would be that Parliament should actually domesticate by actually passing an act which then recognizes the applicability of the commercial competition regulations in Malawi, for instance, or any other multilateral treaty that creates regulatory framework, an international regulatory framework that applies in Malawi. So the best way to do that is to actually ratify the regulations and again the COMESA treaty in order to ensure that there aren't these loopholes. Yeah. Other than that, I think that's all I had. In my view, I think the new act definitely has sealed most of the gaps that were there, and I think yeah, I think it gives the CFTC the necessary power to enforce competition law in Malawi. Thank you very much.
Thank you so much, George, especially on the last point of domestication of COMESA treaty. And I've always wondered why there's a lot of political unwillingness to domesticate this kind of treaties, which I know for the CFTC, this is beyond you because this is not a decision you can make. It has to be made by the parliament, which is a different body, even if you have the willingness to push for the domestication of the regulation. So George, I have only one question for you. I don't know if Leonard also has a question for you. Then we can look at the questions in the chat. When it comes to merger thresholds within the CFTC, and we also have the AfCFTA also coming up with a suspensory mandatory merger regime, and COMESA with the suspensory merger regime as well. What do you think? How do you think this the CFTC will be able to approach the issue of merger threshold in relation to the AfCFTA competition protocol? Oh, you are muted.
Yeah, I think the thresholds that the CFTC will have to look at will have to be focused on internal, the size of the market in Malawi and the type of activities, type of measures that it actually approves in Malawi. Because I think if you look at the COMESA Competition Commission thresholds, I think those have an international sort of a flair to them, and then the amounts there, I think if you were to apply them in Malawi alone, I think you probably leave out a lot of transactions. So if they're going to come up with threshold, they then need to look at what is the biggest, probably look at what is the size of our market and what is the size of or the value of the transactions that we actually approve, and looking at the data that has been there. And I think they've been there for about 25 years, and I think they're able to look at the type of mergers that they look at and then come up with proper thresholds that are specific for Malawi, looking at the nature of the environment in Malawi itself. So I think that's what they should look at. And then if there are any transactions that are, for instance, cross-border within the COMESA region, then we can then move to the thresholds. We can apply the thresholds in under the COMESA. And again, beyond that, again, we look at it from the multilateral level as well. So I think maybe there has to be that tiered approach, depending on the transaction and its impact, whether it's local impact or cross-border impact. Yeah, thanks.
Okay, thank you so much. So Odi, you addressed your hand, so I don't know. Lona, do you have a question for George?
I have a question for Lloyds.
Okay,
before this comes in, rather my
sorry.
question would be to Mr. Lloyds. Wondering what's the new law comes, new powers, with the new law comes new demands, like we've talked about, the novel issues of buyer power, of digital markets, and that does the commission at this point have a specific plan for capacity building, and how do you intend to close the capacity gap within the shortest time possible? Thank you.
So that question is directed to Mr. Nkhoma, right?
Yeah, thank you very much. I hope I'm still audible.
Okay.
Let me take that. Actually, your question is precisely what we have been grappling with, and I think I alluded to in my statement. But to cut the story short, as we speak now, we have already engaged quite a number of stakeholders. Actually, we are working already with the World Bank team on competition matters. And also we are consulting with the EU on similar matters so that we front load issues of capacity building, because they are very, very critical, not only because of the additional provisions of digital markets and buyer power, but even the traditional concepts, some of which have transformed. It requires quite a bit of thorough understanding on the part of us as enforcers, investigators, but also even our commissioners who will be making determinations on those particular cases. So already the World Bank, when we talked, they have given a nod on the preliminary capacity building issues, which are going to involve both staff and commissioners. We are not sure yet about the extent of the coverage, but just to say capacity building is an ongoing process. It doesn't end. We may not have the capacity we need in the next 6 months. We need at least a good number of years to be on top of the enforcement of this kind of regulations. So to cut the story short, we recognize that, and we have already engaged some stakeholders. Things are moving, but we are going to expand this plea so that we expose our staff to these particular enforcement challenges, so that, because now the stakeholders are waiting there. We announced this, the commencement of the enforcement of this law. There's no excuse now. What they need are decisions from us. What if a transaction involving digital markets comes tomorrow? I will not give an excuse as a CEO that no, I'm learning first. Give me a few minutes. Cases have got timelines, so they come, I deal with them, and in the process, we are enhancing our capacity to do that. But very important question, and we intend to do justice to issues of capacity.
Okay, now let's listen to Odi. What was your
Thank
question?
you very much. Thank you so much, Vella. My question is to Lloyds, and it relates to buyer power. Will the Competition and Fair Trading Commission also act against buyers where there is an abuse of buyer power and it is the state? Because we have seen in Kenya, one of the cases in the digest, that they decided not to act against the state. They argue that that is the role of the Public Procurement Committee or Commission. And the dilemma with that is that public procurement and, let's say, non-payment from the state is actually a very huge problem in relation to the sustainability of SMEs in any event in South Africa. And I was wondering whether Malawi would be willing to go after the state in instances of non-payment, for example. Thank you so much.
Thank you very much. And just to say the beauty that in our case, we have already had an experience of CFTC taking other state entities to task. And we have fined state enterprises before. Of course, there were some quarters which said, but what do you mean? It's like account number one of government fining account number one. What do you mean? But it's a matter of bringing sanity on the market. So we have a provision at the very end of even our current law, just as it was the previous one, say this law binds government. So government is also our focus area, much as we don't have critically state aid or state enterprise provisions, but we have used the same provisions to take head on fellow state institutions. And so far, apart from questions here and there hasn't been any backlash as to give us an impression that is something which we cannot do. So we'll pass on that.
Thank you so much.
If government is involved, then we'll pass on.
Thank you, Lloyds. Thank you for that.
And thank you, Odi, for that important question. So we have 2 questions because we don't have time anymore. And we have around 6 minutes to go. And Julia is asking, how does the Act ensure that MSMEs are protected and supported, particularly in light of the AfCFTA and other bilateral agreements where competitors from countries have subsidies and advanced production technologies, especially with the need to boost Malawi's productivity and MSME sector to ensure that our MSME sector is not killed, but also be able to compete with the present and expected increased competition from trade agreements. So she's talking about MSME protection. And then another question so that we answer it together. Luzidamba is asking that Section 35 defines mergers and Section 36 lists transactions that will be considered to be mergers. Is there any utility in having 2 separate sections on what constitutes a merger? Further, Section 37 says that transactions under Section 35 must not be completed unless they are approved under Section 43. However, Section 43 lays out a procedure for transactions under Section 36 and makes no mention of Section 35 transaction. Is this a legislative discrepancy? George, you are really nodding. Do you want to take that one? And then Lloyd can take the other one on the MSMEs.
Yes, no, it definitely is a legislative, sorry for, okay, yeah, it is a legislative discrepancy, because I mean, even when I was talking about the enterprises issue, that it only applies to because that is raised in Section 35, you see, so I think when interpreting those sections, you then have to look at both 35 and 36 as a whole when applying Section 43 and Section 37. Otherwise, I think they should have mentioned that all transactions under Section 35 and 36 and then need to be notified. And then so I think it was a legislative discrepancy, and then it creates sort of these issues of interpretation and loopholes as well. Yeah. So I agree with that observation.
Okay, thank you so much. Mr. Nkhoma, comment on the first one on MSME.
MSMEs.
Yep.
No, I think one of the areas where the law pronounces itself on the protection of SMEs comes under the public interest provisions, especially when we are looking at measures, because we have retained the public provisions. And I think if you look at it clearly, the issues of protection of the small-scale enterprises features highly. So a transaction can pass, though it's controversial. I know people will say, no, you are following the party. What it means is that a transaction, even if it satisfies competition provisions, but it fails on public interest, then we need to find other ways. That's where maybe the undertakings or conditions comes in when you are actually determining that particular transaction to ensure that that transaction at the end of the day does not hurt the growth of the small scale business enterprises. That is under the measures, which I think the question was alluding to by the way the agreements, because the competition law is not implemented in a vacuum. We also have the SME Act in Malawi and the other laws which we have to take into account when these determinations are being made. So SME being the growth engine of the country is always considered under public interest when the decisions on the concentrations or agreements are being effected.
Okay, thank you so much, Mr. Nkhoma, for that. So as we wind up, I'll have just one question from both of you. So for Mr. Nkhoma, one of the challenges we've been having in the enforcement of competition law in African developing countries is the issue of whether we are copy-pasting laws from other regions, especially the EU and emulating other regimes without really contextualizing the same. And I'd like to know if you can proudly say that the new Malawi Competition Act reflects the market realities in Malawi, and which goals of competition law does it really seek to pursue, even when it draws from international best practices. And then for George, from a practitioner's view, I'd like to know if you think the Malawi competition law is adequate in addressing abusive conduct of digital platforms within Malawi. So we can start with Mr. Nkhoma as we wind up.
Thank you very much. Let me start with by saying that our law as it is, as I said, the legislative process started with the drafting by the consultant. Obviously, when consultants are drafting documents, you find that provisions are taken from all angles, looking at different kind of registrations across the continent. That is a fact when consultants are working on documents. But when such a text now is subjected to the realities of stakeholder consultations, it's when now the panel beating starts to ensure that it's not just an imposition of something because it has worked in Europe, then you think that it's going to automatically work in Malawi. And the questions you had on leniency program actually layers bare the fact that possibly there was a copy and paste of a leniency program from somewhere which ended up not working. So this is the process we went through, but if you look at the provisions of the law, we cannot say 100% that it has no borrowed provisions. It has. When you are developing something, you always have to take into account the best practices in the region, but with the view of actually moderating so that it suits your enforcement agenda. So our goal is actually to make sure that we have, just as the preamble of our law stipulates, I think our law has to secure the best conditions we can provide for the freedom of trade and enterprise and the expansion of the base of entrepreneurship in this particular country like Malawi. So it's not just about the enforcement of competition in a vacuum. We now have what we call the Malawi long-term growth strategy, the Malawi 2063, which puts us as CFTC under a pillar which is called the private sector dynamism. That's where we fall under the long-term growth strategy for Malawi. So as we're enforcing the law, actually our focus is to say whatever we are doing, is it actually adding value to private sector dynamism? If it is not, then we have derailed from the broader aspiration of what the government wants us to be. So as we enforce, we also look at quite a number of things. We are not a punitive law. Others will view us that, oh, you just impose fines. Fines come, but our goal is actually to ensure that we safeguard the competition process in as much as possible so that we help firms grow so that they can help in the long-term growth and development aspiration of the country as stipulated under the Malawi growth agenda. So that's all what I can say at the moment, unless if there is any other follow-up question.
Okay, thank you so much for that, George.
Yeah. Okay. I think you also, my question also touched on what the CEO also has mentioned. I think the regulation of various aspects, I think you find that, I think there's usually a tendency to go to the a regulator who who is much more efficient. Yeah, so I think the CFTC itself has actually shown that it can do the work, and it can enforce. I mean, subject to obviously oversight from the courts. But before these court rulings, I think the CFTC was seen as one of the most efficient regulators. But I think we still need to look at things from a holistic point of view, and I think digital markets requires that holistic approach, because you're not just looking at competition issues. I think you would have a separate regulatory authority that deals with communications. So telecommunications and digital markets, again, they also fall under that. So I think if we look at both these acts, the CFTC as well as the Communications Act, when together, I think then you will have an efficient way of regulating digital markets. But if you have a silo approach to dealing with these issues, I think that's where now you'll find that you're not able to regulate issues properly. And that's why I think one of the issues that we also raised earlier on was that how do now these regulators coordinate with each other in ensuring when regulating the various activities of these enterprises that operate both in the telecommunications sector, and when we also have a competition effect, you know. So if you have a framework that allows these regulators to also work together, then I think you'll be able to manage digital markets properly. And because also it has a technical aspect to it, isn't it? And sometimes you find that maybe MACRA, who is the communications regulator, has the tools and also the actual capacity to regulate some of these issues effectively. So I believe a holistic approach is the best way to handle these issues. Yeah. Thank you very much.
Okay, this session was really amazing, and thank you so much, George and Lloyd, for your presentation. Maybe before we just wind up, Angela, are you there?
Yes, I'm here.
Yeah, maybe I would like to know your opinion regarding what are some of the consumer protection issues in online markets that the Act has tried to address.
Can you come again? What online issues that what?
Consumer protection issues within the online markets.
Okay. From the complaints that we have handled before, that we have received before, the online, there are issues to do with maybe false representations. Some consumers complain that what they actually get is different from what maybe had been advertised online. There are those issues, whether it's to do with them, like the maybe different brands that have been advertised, and then they get after purchasing they get a different brand, or maybe issues to do with quality. Maybe you have advertised maybe good quality, but what they actually get is different. And then there are also issues to deal with maybe late deliveries. You find that they purchase something online, and they are promised that it will be delivered within a specified period, but then that period passes, like goes on to maybe many weeks after the actual promised period. So there are those kind of complaints that we have received in terms of online. They are mainly to do with false presentations. There are also issues to do with maybe what we can tell maybe scams, that someone can purport that they are selling some items online, but when it comes to the actual delivery, it doesn't happen at all, and they are also not available. Maybe maybe consumers realize later on that they have been scammed. So there are those online issues. These are practical examples on the cases that we have received so far.
Thank you so much. Maybe we'll have another event to talk about issues of consumer protection in online markets, which is very important because the Act is also looking at digital product and services. So let me take this opportunity to thank the Malawi Competition and Fair Trading Commission for giving us an opportunity to explore and to understand the new amendments, not the new amendments, the repeal of the 1998 Competition Act. And it was really an amazing event today. We've learned a lot. And because these are the kind of amendments and repeals that are happening across Africa, we are going to see how other countries are going to learn from Malawi, especially on the issue of cross-border cooperation, which is one of the topics that I've written a lot on. And thank you so much, George, for the opportunity you've given us and taken us through the merger analysis and what the practitioners and the businesses should expect from Malawi, especially in regard to the merger threshold and also when to file at the Malawi Competition and Fair Trading Commission, when to file at the Commerce and Competition Commission, and if the AfCFTA Competition Authority begins enforcing the AfCFTA Competition Protocol, when to file at the AfCFTA Competition Authority. And with this, I would like to come to an end this session, and I'm looking forward to more engagement. And if you'd like to follow our events on the African Competition and Consumer Protection Center, I've sent the YouTube link, and we'll also upload this on the YouTube link so that a lot of people can follow this discussion and learn about Malawi. Thank you so much. Bye.
Wonderful. Thanks so much.
Okay.
Thank you very much.